Now, our last speaker in the whole conference is Patricia Rickard-Clarke, who has certainly been a great friend to me in any efforts I've tried to make in the Shannon to improve any health legislation. And she's going to speak on the mental capacity in the context of the Mental Health Act 2001. Now, Patricia is a commissioner of the Law Reform Commission, and she's the lead commissioner with regard to the Commission's work on vulnerable adults and the law, which includes the reform of the law on capacity. She's chair of the Law Society's Mental Health and Capacity Task Force and a member of the Law Society subcommittee of the Guidance and Ethics Committee, considering the financial aspect of elder abuse. Now, the last thing, before I left Jana there, and I brought forward was a private member's bill, which was entirely based on the Law Reform Commission's recommendations regarding vulnerable adults and the law. And the most remarkable thing was, I still have people getting on to me saying, when is this legislation coming through? Now, they're more innocent people than I am, and they think this legislation is coming very soon. Well, my mother used to have a phrase, God bless their innocent Irish hearts, but I would be so delighted if I saw it coming soon, because people are expected to taking this all or nothing wardship, when in fact the gradations and guardianship and so forth suggested by the papers with which Patricia has been involved really just could be brought through. It's not a party political issue, and it's just so hard to understand why it's 3 years now and that a thing that isn't a party political issue isn't brought forward rapidly. So we'll hope that I'm wrong and that you're all right. Patricia.
Good afternoon, everybody. I'm delighted to be here, and I thank UCC and the Mental Health Lawyers Association for inviting me. And as Mary said, I'm going to try and talk a little bit with the capacity emphasis and in the context of the Mental Health Act. And really what I would hope to achieve out of this is that I will identify some points that when the capacity legislation is published, that you, with your thinking hat on in relation to the Mental Health Act, that you have very much regard to some of those issues, and that you actually make representations in relation to some of those issues. So if I can start and just say that what I propose to do is just to give a little bit of the background and then to talk about some of the principles in the Mental Capacity Bill. There was a scheme published in 2008, and then go on and talk about some of the issues in the Mental Health Act, and then I suppose address some of those reform issues. So the background was that when I became a commissioner in 1997, I put this on the list of issues that badly needed to be addressed, and I remember a number of people saying to me, it's not an issue at all, what are you talking about? Anyway, the Commission started work in 2002, and we produced our first paper in 2003. And not to delay, but we produced our final report with a draft bill in 2006, and as Mary said, she kindly introduced a private member's bill based on that Commission bill in 2007. And we then had the scheme of the Mental Capacity Bill in 2008, and it was very much heads of a bill and a scheme. If you look at the current business for the legislative programme, you will see that it's on the A list. The A list means it will be published, the detail of the bill will be published in this session, and this session only has a couple of weeks left to go. However, on other inquiries, I know that the person that has been working on it, and the drafts person in the AG's office, has other work to do, so I leave it at that. But a number of people have mentioned the UN Convention on the Rights of Persons with Disabilities, and of course, while we have, and we're one of the first people to sign up on that, we can't ratify it until we have modern capacity legislation, so that's extremely important. It's also very much to that in the regulatory impact assessment, which all government departments now must draft in relation to why a particular piece of legislation should be proposed, that statement said that the terminology and concepts used in the existing legislation, which I will remind everybody is 1871 and back further than that, because the 1871 Act is literally a procedural act. But anyway, it says that that act is inappropriate to modern understanding of mental health and mental capacity. Now, the other two very important recommendations of the Council of Europe are the principles concerning legal protection of incapable adults of February 1999, and the other one, which again I think has, towards the end of my talk, I'll address some of those issues, the powers of attorney and advance directives for incapacity, which certainly have a role. So if we look at the approaches to capacity, first of all, the recognition of constitutional right and human rights law for people who lack capacity. And coming back to the regulatory impact statement, it states that the current law may be in violation of the constitutional and human rights of individuals. And of course, we in our report pointed out, of course, that the current Wards of Court legislation is not in compliance with either of those. And if you look at that Russian case, it is in fact, what we have in our Wards of Court. Now, Anya mentioned this morning the Croke case in 1999, and we have our mental health legislation because Ireland was brought to Europe. But if you think of people who lack capacity, unfortunately we haven't had a case for a person who lacks capacity being brought to Europe. And if we were, we would be blown out of the court, because we don't have a fair hearing. When the Commission produced its first paper in 2003, we pointed out there that the subject of the application to be taken into wardship, didn't even see the medical reports. Now, that has changed since the publication of our reports, but the person is not present for that hearing either, which of course is a huge issue. So what's a fair hearing? And also then, those hearings, that Russian case pointed out that the person in question, it was only before the court for 10 minutes. So if you're assessing a person's capacity and trying to find out and taking away their decision-making ability from them, is 10 minutes in a court sufficient time? So all of those are terribly important. Now, just to say, and I won't get into the detail, Anya has already mentioned the functional approach to capacity, and if I can just say that the Wards of Court assessment of capacity or the model that's used is a status approach. So in other words, somebody raises an issue as to whether a person lacks capacity, and then a decision is taken by the court that they lack capacity for all purposes and makes a determination of that. That's what's called the status approach. The outcome approach is where maybe a doctor might, like in the C case in England a number of years ago, said a leg needed to be amputated, and the person disagreed with the doctor, and the doctor then decided that person lacked capacity. That would be the outcome model. And again, the court in that case said no, that the person understood the implications of not having his leg amputated, and found the person had capacity actually in that particular case. And then we have the functional approach. Now, the functional approach actually is the common law approach. In making wills, it has been the approach for a long number of years. You assess whether the person has capacity at the time the decision has to be made. So in every decision that has to be made, it's issue specific and time specific, and I'll come back to that again. Just to say that recent acknowledgements, even though we still don't have the legislation, there has been a move towards the functional approach. So we have Mental Health Commission, we have the HSE in relation to the recent schemes of Fair Deal, etc., actually spelling out in secondary legislation the functional approach. We've HICWA spelling it out in their codes. We've the Medical Council now very recently in their new guidelines accepting that, and as I mentioned, the legislation and some case law, some recognition of that. Moving on then to the Act itself, and I'm only touching very quickly some of these issues. I suppose I should say that, first of all, that what the legislation attempts to achieve is the appropriate balance between autonomy and protection. And of course we're talking about autonomy, and autonomy isn't absolute either. We're talking about very vulnerable people. At the same time, they do need to be protected. So it's that balance that is terribly important, and it can be very difficult to achieve. Again, to reiterate what other people have said, that human dignity is not dependent on a person's mental capacity to function. A person who is vulnerable, who has a mental illness or a mental capacity, has all the rights of any other person who has full capacity and is not vulnerable. And the need to respect their right of the person to the dignity, bodily integrity, I would absolutely emphasise, terribly important, privacy and autonomy. And we have to have a system whereby if people are unable to or lack capacity, at what level do they need assistance, or at what level should that be substituted decision making? Now, again, there is in common law a presumption of capacity, and when the Commission was looking at this issue, we felt it was terribly important to have that set out in statute so that it was up there and very clear, because again, everybody knows that if you see, say, for example, a child or a person with Down syndrome, there's an automatic assumption that that person lacks capacity. And that may not be the case. Similarly, with an older person who has been diagnosed with Alzheimer's, there's an automatic assumption that person lacks capacity. That may not be the case. They may have capacity for some decisions, and they may have quite high levels of capacity. So that's what the functional test is trying to do, is to involve them in the decisions insofar as they have the capacity to be involved in those decisions. So a terribly important issue. And just to go through the definition in the scheme of the bill, it's the ability to understand the nature and the consequences of the decision, the available choices that are made at the time the decision is to be made, functional approach, the risks that are involved, terribly important. And the fact that the lack of capacity is where a person does not understand the information, but it's terribly important that they are assisted. And again, the Act goes through that they must be assisted in making the decision. So if they are assisted and then able to make the decision, then that's not determined that they lack capacity. So it's the way they're given the information. And again, you could have, say, language situations, you can have education situations, all of that must be taken into account. So the person that's assessing the capacity must have due regard to all of those issues in assisting a person. And then the reasonable and foreseeable consequences are terribly important. And again, this was borne out in the FK case in 2008, where Mrs. Justice Lavoie said that where she found that person lacked capacity because they had not comprehended or retained the treatment information, and in particular had not assimilated the information as to the consequences likely to ensue for not accepting that treatment. As you may remember, that was a Jehovah's Witness blood situation, and the patient said, well, if I had Coca-Cola and tomato juice, I could be okay, it was instead of blood. And Mrs. Justice Lavoie went through all the issue of how you assess capacity and whatever. It was a very good case in that regard. Again, it's on the civil law test of the balance of probabilities. Now, again, on to the best interests. And just to say that you see the issues of, in the principles of the Act, dignity, bodily integrity and privacy and autonomy are in the principles, not in the best interests in the Mental Capacity Bill, as distinct from the Mental Health Act, which includes those in the definition of best interests. And there was I can't remember the name of the case now, but one of the cases did point out, of course, these were principles that apply anyway, regardless of what you're doing under the Mental Health Act, and I would agree with that. Now, in terms of the bill, the scheme of the Mental Capacity Bill and best interests, it does spell out in much more detail, and this is terribly important to enable individuals interpreting the legislation, but also indeed the court. So So must consider all relevant circumstances, whether capacity is likely to return, etc., and if so, when. Permit and encourage the person to participate, take into account past and present wishes, beliefs and values and other factors, and take into account views of specified others. Now, just to say, I'll just hop to the key case in the UK, and that was a case for, again, a person who wanted to make, or at least there was an application to make a statutory will, and the court was tasked with the interpretation of what was the best interest in that person. And these particular things, the wishes of the past and present wishes, whatever. And the judge pointed out the fact that the person lacked capacity, you couldn't ascertain what their past or present wishes were. This was a balance sheet, Mr. Justice Lewisham said, and you had to look at all of those issues. However, at the end of the day, having drawn up your balance sheet, then you must form a value judgment, the person acting in the best interest, and giving effect to the statutory provision of what is in the best interest. Now, that again is a difficulty, and I suppose previously when best interest used to be debated in the cases, it was very much a subjective approach. Then it became a subjective stroke objective. So, I mean, it's the issue of all of these things, and it's a difficult one, I must say. Moving on, though, to the relevant circumstances are terribly important, because, again, in making the decision in the best interest, the person is obliged, the person who is determining what is in the best interest, is obliged to take into account all relevant circumstances. So they're under an obligation to make themselves aware of the particular personal circumstances of that person, and also to be reasonable in regard to what is relevant, so not to take in all sorts of irrelevant circumstances. So that's an important qualification. Now, I'm not going to delay on this because other people have, but my thing is that in terms of this, I do feel that best interests for the purpose of the Mental Health Act does need to be spelt out in some, there must be some handles that people can hand things on. I do believe it's a holistic approach. I do not agree with the contention that it's either legal best interests or medical best interests. I think it has to be a holistic approach to best interests, and that's a difficult one in itself. I would also talk about, in terms of paternalistic, I would refer back to what we in the Commission spent a lot of time looking at, the balance between autonomy and protection. And I think paternalistic, terminology I think is terribly important, and I think paternalistic is archaic, it's out of date, etc. And I think the balance has to be between the protection and the autonomy, and that can be a very difficult balance to achieve. But I think that's, anyway, that's my view on it. Moving on then to the principles, I suppose, of the Mental Health Act. The core issue in that is the principle of involuntary detention. However, that Act, the Mental Health Act, enshrines the general principle that the consent of the patient to medical treatment is absolutely necessary. And but also, the presumption of capacity is there. Now, I would like to see the presumption of capacity spelled out in that Act as well, because I think people constantly need to remind themselves that the presumption, so all the treatments and the consents, you start out with the presumption of capacity, and I'll come on to the incapacity in a minute. The requirement to the consent to medical treatment and medical examination, of course, as we know, is a constitutional law right of bodily integrity, and it's one of those unenumerated rights in Article 43. And to quote Mrs. Susan Denham in Ray Wards of Court Number 2, if medical treatment is given without consent, it may be a trespass against the person in civil law, a battery in criminal law, and a breach of the individual's constitutional rights. The consent which is given by an adult of full capacity is a matter of choice. And also in the FK case as well, of course, and indeed the Wards of Court case, there was a recognition that a person had a right to refuse medical treatment. So that's a terribly important thing, consent and refuse. And again, the human rights jurisprudence suggests that compulsory medical intervention or psychological examination may interfere with the rights under the European Convention of an individual. Moving on then to look at, so just to say that of course consent to treatment is still required for the purposes of the Mental Health Act. And as we know, Section 56, I'll come back to some of the comments that Mary made earlier. Section 56 provides that it goes through a series of steps, the capacity to comprehend and decide, the risks involved, the information must be given, and they must understand and assimilate that information. Now, all of those are terribly important. And of course, consent means consent obtained freely without threats or inducements. However, it is then, I think it falls down on the point that Mary made. The Act recognises the right of the person to make decisions and consent to treatment, but then it allows the consultative psychiatrist to overrule that. And I think without any safeguards. And I would say, okay, in certain circumstances that may be necessary, but there should be safeguards there. Now, the guidelines, the mental health guidelines, also goes on to say that the greater of the patient's capacity to comprehend the issues involved and make a decision in relation to them, the greater will be the extent of the duty to disclose all relevant information. The greater the risks to the person which the doctor knows or ought to know, the greater will be the duty to disclose that information of the risks to the patient. I think they're terribly important. And those guidelines are fleshing out some of the details of the Act. If we had some of that in relation to best interests, it would be of huge benefit. The doctors also must take into account the effect of the information on the person. So if the person is very ill, maybe there isn't the same level of disclosure. Very, very important is the issue of the consent seen as a continuing process, not a single event. So again, issue specific, time specific, so it's a continuing process. It's not, are they consenting to this treatment? You go through each stage in the information and the risks, etc. Very important. Moving on then to Section 57. As we know, under the general common law is that if in an emergency situation a doctor can treat a patient where it's absolutely necessary to do so. Now, in England there have been a number of cases discussing the issue of the doctrine of necessity, whether it's in an emergency situation only or it's where is it in a case of a necessity to act. And that doctrine really hasn't been developed in this jurisdiction. However, this is the first time that we've seen it, if you like, in some form of statutory form in an act. And of course, Section 57 provides that where treatment does not require consent. Now, just to, I suppose, hone in on some of the wording of the legislation, the consent of the patient shall be required for treatment except where, again, in the opinion of the consultant psychiatrist responsible for the care, etc., of the patient, the treatment is necessary to safeguard the life of the patient, to restore his or her health, to alleviate his or her condition, or to relieve his or her suffering and by reason of his or her mental disorder, the patient is concerned is incapable of giving such consent. Now, I would just highlight the wording. By reason of mental disorder, the patient is incapable of consenting. If a person lacks capacity, it doesn't give any out in Section 57. And I think that understanding is extremely important. So it's really quite narrow, and I think from talking and asking questions about this, I understand it is used for people who lack capacity. And that is where the capacity legislation is absolutely vital, that where you have Section 56 and 57, and indeed some of the other later sections with regard to medication and treatment, you have to have very clear safeguards and very clear statutory provisions as what is to happen in those circumstances. And I would also say that in relation to these, that for people who actually are deemed to have capacity, are people, is it really explained to them the implications of all of this? So I just highlight that. So lack of capacity in itself, not sufficient. Then on to other forms of treatment. I won't delay here, but psychosurgery, the consent of the patient is required and it must be authorised by the Mental Health Act. I understand psychosurgery has not been given. But again, no provision in the legislation about if the patient lacks capacity. Now, the next two sections in terms of ECT, section 59 and the administration of medicines, and I'm highlighting unable and unwilling. And I've heard Minister Maloney saying that the unwilling, yes, will come out. I'm not too concerned with the unwilling at the moment, although it has to come out. What I'm honing in on is the unable. And I would interpret that again very narrowly. What does unable mean for the purpose of the Mental Health Act? Is it unable because of the mental disorder and the mental illness? Or is it unable because they lack capacity? And I would say that that needs to be spelt out. And I would say that for the purposes of this Act, unable is not good enough for a person who lacks capacity. It may be unable because of their mental health condition. So I think that's a big gap, again, for people who lack capacity. Moving on then to a person who lacks capacity and the transition from involuntary to voluntary based. And I know there was a bit of conversation in some of the questions this morning about people who are voluntary patients. Again, on talking to people, to doctors, lawyers, etc., I understand that there are a number of people who are deemed voluntary who lack capacity and were involuntary and now voluntary. And I'm again of the school that voluntary has to mean consent to something. It can't mean anything else. I think huge questions should be asked by both doctors and lawyers in relation to that. So where people lack capacity. So if we're waiting for mental capacity legislation, I think that those issues need to be addressed in practice and raised in practice, because it is only when people start talking and really pointing out the difficulties that people stand up and take note. And I don't think that hasn't really, come out sufficiently strongly. Now, in terms of the voluntary patient, again going back to the definition in the EH case, the definition in the Act, and indeed as interpreted in the Supreme Court, not subject to admission or renewal order. And in the beginning, I was saying to myself, well, okay, in terms of that decision, really at the end of the day, the ratio or the reason for making that decision was in relation to section 23 and 24 was the involuntary, voluntary, and it really should the articulation about the definition of a voluntary patient or voluntarism in it wasn't particularly necessary for the purposes of the Supreme Court decision. However, I have seen some documentation recently that I really was concerned about, and that is that I feel, and again in the Commission we look at how legislation is drafted, the purpose of legislation, what you want to achieve. You cannot decide to, exclude a whole cohort of people because the way you draft legislation. And so in the Mental Health Act, you have people who are involuntary detained, a certain procedure, and you have people who can consent, who are voluntary. But people who lack capacity, you can't just exclude them. And I'll move on to the draft of the bill in a minute to talk about some of the questions. But one of my big fears in the mental capacity bill, there was nothing in the scheme as published in 2008 which would dealt with any of these questions in relation to people with a mental health issue who lacked capacity. And on a more recent draft that I saw some improvements, but in relation to this particular question, there is nothing. Now, to me, that tells me something very significant, and that is that because it's defined in a negative way and it's not defined in very much a positive way, that it's not going to be addressed. And I think that's a very serious issue. So when the bill is published, I think people have to campaign to make absolutely sure the definition of voluntary is spelt out. Now, I would go further and say, raise the question as to whether one should have, for people who lack capacity, informal or some other terminology, but I go along with voluntary, provided all the safeguards were in there. So that's one of the big concerns I would have. Moving on then, to say that, of course, the doctrine of necessity, and Mary sort of said also, and indeed the Mental Health Commission guidelines say that for people who lack capacity, then they can be treated under the common law. Now, the doctrine of necessity can only be used as a defence. It's not a substitute for consent. Again, I would say that's only in emergency situations, and it cannot be used to say that you're acting in the best interest of the patient, because if a person lacks capacity, there has to be very clear legislation to deal with that. Who can make the decision and the reviews? Now, other people have commented on the lack of review throughout. A person who lacks capacity, who is a voluntary patient, doesn't have a review. The wards of court situation, we have a situation again which is very unwelcome in the Mental Health Act, not only unwelcome, but again not in compliance with the Human Rights Convention, that for people who were wards of court when that legislation, when the 2001 Act came into operation, and they're under the jurisdiction of the High Court, they're excluded from any of the safeguards in the Mental Health Act. And that's a very serious situation. Now, when the draft bill, the draft scheme of the Mental Capacity Bill was published, that was not addressed. I understand it now has been addressed in the recent draft. Also, the question of the scheme of the Mental Capacity Bill, when it was published, there was this suggestion or the situation that anybody coming in to the system post the publication of the bill would have a review under the new mental capacity legislation, but anybody that was there, and I'm not talking about people now under the Mental Health Act, I'm talking about people just who lack capacity, had to request a review, which again was in breach of the Human Rights Convention. Now again, that has been taken up in a more recent draft, but the voluntary patient who lacks capacity is still a huge issue, and I couldn't emphasise that more enough. Moving on then, in relation to enjoying powers of attorney, under the current legislation, as you know, a person cannot appoint an attorney to make decisions in relation to their care and treatment. I'll just hold that for a moment. Under the draft bill, there are a number of alternative ways of decision making for people who lack capacity. First of all, we have an informal decision-making structure where that if a person doesn't act, again, it's like the doctrine of necessity, it's a defence rather than a substitute decision-making situation. If a person doesn't act in relation to the personal care, healthcare treatment of a person and abides by the principles in the Act, then they can't be found to be negligent. Now, the Law Reform Commission were very clear when they were saying about informal decision-making. As you can imagine, lots of people who have intellectual disability, etc., and you have a lot of very low-level decisions that have to be made on their behalf. And we approach that as informal decision-making. This is in relation to, going to the dentist and things like that. However, we were very clear that there had to be very clear safeguards in relation to that. In the draft bill, those safeguards are not there, and I raised that. Again, personal welfare decisions are now expanded in the new draft legislation to include the right of an attorney to appoint somebody for consenting to or refusing treatment. Again, I would say that more safeguards needs to be there, particularly in relation to people who have a mental disorder and lack mental capacity. What's there in the current draft is not sufficient. And again, knowing the way people select attorneys, they may not be the best people, say, in managing business affairs on the one hand, and in making decisions in relation to care and treatment or mental health care decisions or treatment decisions, terribly important. So those need to be addressed. The scheme includes provision, and I don't have time to go into it, a personal guardian if there is a declaration that the person absolutely lacks capacity and a personal guardian is appointed. And then there's a public guardian. A new office of public guardian will be established. It will be an independent office, and there'll be a new offence of abuse and neglect of people who lack capacity, which is terribly important. I put in brackets there tribunal because the Law Reform Commission recommended that there should be a guardianship board, and in the first draft of the scheme of the bill it comes out as jurisdiction in the court, and again I raise issues about that. The Commission also did a report on advanced care directives and produced again a further draft bill last year. We excluded advanced care directives in relation to mental health because we felt it required quite an independent study on its own. I think it's an extremely important issue in terms of people who have mental health problems have experience from time to time, and they may want to put in a care plan, what they want, etc. And appoint a mental health care proxy or something like that. I think it's an issue, it's terribly important. In other words, when they come to a situation that they're very vulnerable and can't make the decisions for themselves, at least they feel they've appointed an individual and they've let their views, etc. be known. The issue then of that must be clearly addressed is the detention of people who lack capacity. The whole issue of consent for people who lack capacity. And again, where that interface between the mental health and mental capacity, should it be in the mental health legislation or should it be in the mental capacity legislation? I don't have a particular hang-up as long as people are very clear what is the position and the safeguards are very clearly spelt out. I say there that the clarification with regard to safeguards for informal decisions and enjoying powers of attorney, and then we need the advanced care plan. Very briefly then, just to end, is that again the Commission has just recently published a paper on consent to treatment for children. And as we know in the Offences Against the Person Act, a 16-year-old can consent to medical and dental treatment, but it does not, or it's unclear as whether it includes mental health treatment. And the Commission has provisionally recommended that a 16-year-old should be able to consent to their mental health treatment. We also have the voice of the child in relation to the 14 to 16-year-old, 14 and 15-year-old, and then below 12. But again, we have had a whole chapter on the Mental Health Act on children, and we feel that the District Court is not the appropriate place to make an application for involuntary detention. It should be a tribunal with an age-appropriate focus. We say children should have an independent advocate, terribly important. The Stork case was clearly that young girl in Germany was her parents were the cause of that, and probably right was not on the side of the parents. It wasn't the child. So terribly important that the child is independently dealt with and the child's needs. In our research, we came across quite I suppose articulation of the voluntary detention being used instead of involuntary detention for children, because parents could use the voluntary route and avoid going to the district court. Now, if a person needs to be, or the child needs to be involuntary and needs treatment, whatever is appropriate for that child's treatment should pertain. And we said, of course, that for taking into account the age, so you have involuntary, you have voluntary for the 16-year-old plus, and you have informal patients then for the below 16 years of age. Administration of medicines, we said, does, for children in particular, does need review. As you know, the timelines are much lengthier in the Mental Health Act. And then the participation of the child in the individual treatment plan, again, for the child. So just to conclude by saying thank you again, and this capacity legislation is extremely important, certainly on what the first draft told us. I feel that there are a huge number of issues still to be ironed out, and I would ask everybody, as I say, who who are interested in the mental health issue and mental capacity, that they really do their homework on that and really do make representations. Thank you very much.